They kicked us outside.
Yes?
I think you drank too much.
Not a bad thing.
I'm just thinking.
Not a problem.
Not at all. Not at all. Story of my life. Out.
Yes. Aw. So, under the heading of what not to do when getting married, what are some things that your real estate lawyer might not actually tell you about in terms of purchasing stuff under joint names?
So, it's often the case
Yes?
that people will, in either a moment of haste or out of the goodness of their heart, decide that, this new person is their forever love. And to show them just how sincere they are, they're going to take a significant asset, often a home that they own beforehand, and they're going to go and put it in joint names. Look, honey, this is how much I care about you. Look, I put the house in both names. Now, let's talk about the big distinction between married and not married, because if you are married, the home in which you're living at the time of separation becomes a matrimonial home. And if you don't have a marriage contract, that home's going to be 50-50. But today, so many folks don't get married. But so many of them at the same time will, for the same reasons, take that significant asset and they're going to go and put it in joint names. And they don't understand that the moment they sign that over and put it in joint names, not because they're trying to protect it from creditors, not because they're worried about one day losing mental capacity, so they're setting up an informal lawful attorney guardian arrangement, but because they truly want to show how much they love this person, so they are gifting them with something. But they seem to think that, well, because it was mine before, even though I put it in both names, if we split, I keep it. Full stop. No, you don't. In fact, odds are you gave away half.
So you signed your life away.
So if you've acquired a nice home and, you're in your, what does Frankie Sinatra call it, the September of your years, and you're in your 40s or your 50s, and you meet a new partner that you're going to live with, and that house is worth $1 million, and you go in one day to your friendly real estate lawyer who's been that lawyer for years, and you don't ask him or her the question, you just say, I want to put the house in joint names with my new partner Fred over here, and they say, okay, and they make sure that you're competent, and you know your name, and you know it's Friday, and you know it's June, and you know where you are, and okay, you have competence, sign away. They prepare the documents, you sign it. It's simple. It's a nice $750 transfer. It's easy peasy. You just gave away half the house.
Right.
And odds are if you separate a year later, a month later, a week later, you're going to face a Partition Act application to sell that house and give 50% to the person you just put on the deed. And it's not uncommon that the real estate lawyer doesn't necessarily say, well, hang on a minute. Let me sit you down for the next hour and explain all the consequences that may come from doing this and what your rights and obligations are going to be. Talk to you about having a cohabitation agreement and to exclude the asset and all these other things. And it's a problem. I deal with a significant number of files where people will do that, or they'll have investments and assets and bank accounts, and they'll suddenly put the other person's name on them, forgetting that maybe they've got $100,000 sitting in there, and ostensibly they may, subject to certain rules about advancement that are a bit complicated for this discussion, but they may have given away half of it. And these folks need to get advice, because if you were to ask them at the moment of signing, by the way, is it your plan if you split up in a month that you're giving them a check for $500,000? They'd say, well, hell no. Well, then why are you putting your $1 million house in joint names? That's the equivalent of giving them $500,000.
Right.
Oh, no, but it was mine before. Well,
that
not
doesn't mean anything
if
after that.
you put it in joint names.
Right.
If you keep it in your name only and you're living together and they come in and they move in, then odds are, unless they make a huge amount of direct or indirect contributions to that asset and it goes up in value, odds are they're entitled to nothing. It's yours and you keep it.